Morning, Mr. Harwell.
Good morning, Your Honors. May it please the Court, my name is Jonathan Harwell. I'm here on behalf of the defendant appellant Boone Beverly. If I could reserve 5 minutes of my time for rebuttal. I think this is a fairly focused argument, and I may not even need all of that time. I want to briefly go over the facts, and then I have, I think, 4 points I want to make, all relating to the same issue. The details of the underlying cases are not really that important. Mr. Beverly was serving essentially a 10-year sentence on probation for a number of different charges. He ran into difficulty with that probation and a violation warrant was issued. There was then was brought into court for the probation violation. There were 2 hearings. At the first hearing, defense counsel said essentially we hadn't really had a chance to meet with Mr. Beverly to start to work on a plan or proposal, but there were out-of-county witnesses who were available, so the court said, we'll go ahead and take the witnesses and you can work on the plan for next time. The court then heard 2 law enforcement witnesses from Union County. The court then essentially made a factual finding that Mr. Beverly was in violation of his probation. We're not disputing that factual finding. Court sort of doing the 2 steps of the Dagnan process separately, and the court continued the case to the next date for defense to come up with a proposal and to consider the sanction, the consequences of this violation. At the second hearing, defense counsel's request was actually that not been able to obtain any specific treatment program because the defendant had an out-of-county hold. Defense counsel requested that the Knox County case be continued, that Mr. Beverly be released to the hold out of county to deal with that case, to come back and then maybe be able to put together a plan. The state essentially said, let's just do it now. The trial court then started talking about, again, repeating the facts from the prior hearing that led up to its conclusion that there had been a material violation. Defense counsel then said, Your Honor, Mr. Beverly has something he would like to tell the court. And the court responded, well, I mean, revocation proceeding is, he's not really entitled to allocution. So as an initial hearing he was, and he did, and then the court went on to find that Mr. Beverly should serve his sentence in prison. So the essence of our argument is there was a request from Mr. Beverly to speak to the court to essentially provide allocution at the probation revocation hearing, and that request was denied. We assert that was error. As I said, I have 4 points to make. The first one is the issue that is actually disputed on appeal, which is that the state says that we have not preserved this issue. And I don't really know what to say to that other than to point to the record, which shows there was a request by defense counsel. There was a ruling by the judge. The judge understood what the ruling was, what the request was. The judge made a ruling. The judge even provided a legal explanation for his ruling. He understood the defendant wanted to allocute. He said the defendant didn't have the right to do that and moved on with the hearing. I've cited in the reply brief what I think is the most relevant rule, Rule 51 in this situation, that it's sufficient that at the time the ruling is made or sought, informs the court of the action the party desires the court to take. Here, defense counsel said, Mr. Beverly wants to talk to you. Judge says, I'm not going to let him. As I understand it, the state's position is that at that point, defense counsel should have said, objection, but I don't believe that is required when we had a request and a ruling. The essence of the waiver doctrine is you can't raise something for the first time on appeal. Here, we're raising it for the second time because it was clearly raised before. As I said, that's the issue that's joined in the briefs in the sense that the state has argued that this issue was not preserved and then has argued that we did not make a plain error argument. I agree and concede, or am proud of, or something, that we didn't make a plain error argument. We didn't, because there was no need for it. Issue was preserved. This does leave us, though, in a sort of weird position in that the state did not present a fallback argument. That is to say, in the brief presented by the state does not actually argue that this ruling was correct. The state doesn't say there is no right of allocution. The state doesn't say that the judge was right not to let Mr. Beverly speak to him. The state has put all of its eggs in the "this issue was waived" plain error basket. And I think that it either puts this court in a quandary or perhaps gives this court an opportunity. The Supreme Court in Bristol made clear that it is not the role of the courts, certainly not the role of the appellate courts, to construct the arguments for the litigants. Here the state has declined to make an argument that there is no right of allocution at a probation revocation hearing. I don't think it is appropriate for this court to make that argument on the state's behalf. As I said, maybe there is an opportunity here, and that I think what the court can do and perhaps should do is to defer this maybe a novel and more difficult issue to another day, in the sense that this court can issue an opinion saying we have raised this issue. The state has argued only that we waived it. We did not waive it. The state has not made any substantive arguments on the merits, and the state therefore has waived any argument that this ruling was correct. And because the state has made no argument that this ruling was correct, that this court doesn't have to evaluate whether the ruling was correct, but simply a remand for a resentence.
Well, could this court also request the parties to address that issue, supplement?
I won't tell the court that it can't do that. I mean, I don't know why the court would. The state had every...
You said it's a novel issue, it needs to be addressed, and you said do it for another day. Maybe we could do it for another day, but ask you all to help us.
But that's fine. I don't think there'd be any impropriety in that, other than it does sort of...
I'm not saying I agree with you. I'm just saying you said put it to another day.
My policy argument would be that the reason we have this round of briefings is to flesh out the issues. And if the state has made a decision that it does not want to make an argument, there's a consequence to that. And I would certainly... If I don't make an argument, generally the court rules that I have waived that argument and lose on it. The court doesn't say, do you want a second try at it? To the extent that the court does wish to address the substantive issue, as I said, I think this is a novel issue in the sense I couldn't find any case law directly one way or the other. What I've pointed to in the brief, which I think does resolve the question, though, is case law from this court discussing what happens at the probation revocation decision. In particular, I've cited the Rand case, which was a published decision by Judge Greenholtz out of this court, in saying that when we get to the consequence decision, the sort of second stage of Dagnan, that one of the things that has to be considered is, quote, a defendant's acceptance of responsibility and expressions of genuine remorse, end quote. And I think that criterion, if that is to be considered, certainly the best and perhaps the only way for a trial court to be able to evaluate that would be to hear from the defendant themselves. I don't know how a trial judge evaluates genuine remorse if the defendant is not being allowed to speak. And the final point I will make, and this was fleshed out, I think, in both of our briefs. At this point, we don't know what Mr. Beverly would have said, and under some sort of traditional harmless error analysis, this court might try to sort of parse, well, is there something that he could have said that would have changed this outcome? How bad were his violations? All of that kind of thing. I point this court to, I think, the persuasive issue about the right of allocution at a sentencing hearing and the Supreme Court's decision, this court's decision in Keithley, in which the court said, if the right of allocution at sentencing is denied, we don't have a normal harmless error analysis because of the truly discretionary nature of the evaluation of someone's honesty, genuineness, remorse. It's essentially impossible for an appellate court to determine whether an allocution would have made a difference or not. And so unless you're in a situation where the defendant already has received the absolute minimum possible, the Keithley decision says that if the right of allocution at a sentencing hearing is denied, the sentence has to be vacated and remanded for resentencing. And our position would be all of that logic certainly applies to the probation and revocation decision. And this court should not be in the business of trying to guess, well, what could Mr. Beverly have said and whether that could have made an impact upon the trial judge. Rather, the appropriate remedy is to vacate the order of revocation, send it back to the judge, and allow Mr. Beverly to speak to him. It may be that the judge reaches the same conclusion again. It may be that the judge does not. He will at least have information in front of him to evaluate acceptance of responsibility and genuine remorse, and will also sort of, I think there is a benefit. I've cited some of the sort of federal cases dealing with similar issues. There's a benefit to the public and to the defendant as well of being allowed to speak his piece and be a participant in the process. Beyond that, Your Honors, I will reserve the rest of my time for rebuttal.
All right. General?
May it please the court, Catherine Redding on behalf of the state. So I will just say that in arguing waiver, the state's position was that the defendant said, I would like to address the court, and the court said, well, jumped right to allocution, said, well, you don't have a right to allocute in a probation revocation hearing. And the defendant did not then say, well, no, under these cases, I do. But I take the defendant's point that saying, I would like to address the court certainly brings it to the trial court's attention that the defendant would like to speak. But the state's position is then also whether this court conducts plain error review or plenary review, the defendant is not entitled to relief.
So the language that the defendant's lawyer used was the defendant would like to say something to the court?
I quoted it in my...
what was the exact language?
It says, Mr. Beverly has something he would like to tell the court before I think where we're going. And the court jumped immediately to allocution. So, I mean, it's clear that the defendant wanted to address the court.
So the words allocution did come up or did not?
In the trial court.
He said that no
yes.
Allocution. Okay.
So,
gotcha.
Whether this court reviews for plain error or for plenary review, it's the state's position the defendant is not entitled to relief. It's also the state's position that the arguments made in the state's brief under kind of the rubric of plain error review clearly preserve a response that the defendant is not entitled to relief under plenary review. Because as the state argued in its brief, this court has never held that the right to allocute applies in probation revocation hearings, such that this trial court's refusal to allow allocution at the hearing on the consequences of the violation is reversible error. And there are likely two reasons for this. First, there is no constitutional right to allocute even at initial sentencing hearings. And while the legislature has provided a statutory right to allocute at original sentencing hearings, it has not extended that right to revocation hearings. And that is all in the state's brief. And that is enough to establish, clearly put before this court, the state's position that the defendant's not entitled to allocute at the probation revocation hearing, and so the trial court could not have erred in denying him something he was not entitled to. And even if the trial court did somehow err, that error was harmless. I mean, this comes, obviously, because the state presented this as under plain error, the words are slightly different, but the argument is the same. Under the consideration of the error is necessary to do substantial justice translates very cleanly into a harmless error analysis, and the state's position is that even in this context of a sentencing hearing where a defendant does have a statutory right to allocute, such as at the original sentencing hearing, this court has said that an error from the denial of the right to allocute is harmless if it has no impact on the sentencing, on the outcome of the sentencing. And certainly, as defendant has pointed out in his reply brief, in those cases, no impact refers to, well, the minimum sentence was what was imposed. But it's the state's position here that this defendant has already been sentenced. We are here on probation revocation. So if we're arguing that harmless error in the context of a probation allocution or probation revocation hearing must mean, because it means at the sentencing hearing, no impact, it must mean, or minimum sentence, it must mean that you can only find harmless error if the trial court put the person back on probation and didn't impose any consequence for the violation.
In this case, the defendant was on probation for theft-related and drug-related charges, and that he picked up then new drug and theft-related charges?
Yes. So he had originally pled to theft and drug charges and possession of a weapon. He got
10 years.
Well, he got 3 years and then suspended to 1 year after confinement. Then he violated and picked up new charges. On the original ones, he got a second chance on probation. On the new one, he got a 7-year sentence, also probation.
So that's where the 10 years.
So that's where the 10 comes from. So we have we're on our second violation and one on first.
The violation for this last time was based also on theft and drugs?
Yes. Absconding, picking up new charges, which were very thoroughly detailed at the revocation hearing. And so it's the state's position that if this court is going to find for the first time that a defendant does have a right to allocute at a probation revocation hearing, despite the fact that there's no statutory or constitutional right, and this court is going to find that there is a harmless error analysis that needs to be conducted, it should be different than what is conducted for a denial of allocution at an original sentencing hearing, because probation is different. I mean, there is no statutory right to allocute at a probation revocation hearing, and probation, as we understand from the case law, is different from original sentencing. And here, even if this court were to engage in the analysis, we have a defendant who has had multiple chances on probation. This violation occurred within 4 months of his second chance on probation. There's a warrant saying he's violated by testing positive. He then violates further by absconding, further involving himself with drugs, picking up new charges. This is a situation where the trial court heard extensive testimony about these new violations.
So generally speaking, if a judge is presiding over a matter and he has a represented defendant, that during the trial or pretrial matters or post-trial matters, other than by statute, does the represented defendant have the right to just speak anytime he wants to about any issue that he wants to? Or is it, I mean, I can't think of any statute anywhere other than perhaps the sentencing statute that talks about a defendant having the right to speak. Otherwise, are you familiar with any statute that says that? Otherwise, the judge has authority to determine how hearings should proceed and who speaks, right? My understanding is it's pretty, I mean, trial courts have the discretion to run their courtrooms and run their hearings. It is clear defendants have the right to put on testimony at trial. They have a right to present evidence at trial, evidence at sentencing hearing, evidence at probation revocation hearings. The right to allocute is statutory for original sentencing hearings where the actual sentence is imposed, but that statutory right has not been extended to revocation hearings where the defendant has already been sentenced, has already had his opportunity. I was thinking about even before you ever get to a sentence, even before where you still have a trial or you're having preliminary matters.
Right.
I mean, he doesn't get to raise his hand and say, Judge, I'd like to chime in here.
And I will say, that is something that you see frequently, and you just as frequently see trial courts say, no, this is not the time for you to address the court, or you, like, this is, your lawyer represents you, your lawyer will speak for you on this matter. And given the absence of any law, statute, constitutional provision that says a defendant has a right to allocute at a probation revocation hearing, the trial court saying, no, you cannot address me, no, you have no right to allocute, cannot be error. And even if it is, if we get into the harmless error analysis, the defendant did not make any offer of proof to establish what he would have said had he been permitted to allocute. And we have a trial court who had a very extensive hearing on the nature of the violations themselves. He heard counsel say that the defendant thought he could take care of his other charges and that counsel was trying to get him into rehab. His allocution likely, we have to presume, would have related to his personal circumstances, but Dagnan sets out several factors that a trial court can consider when deciding the appropriate consequences of a probation violation, and the amenability to correction is just one of those. And when we look at a defendant who's repeatedly failed to comply with the terms of probation, cannot show a reasonable likelihood that the trial court would have reinstated him to probation had he been afforded the opportunity to allocate. We don't know what he would have said. Case law is replete with statements that probationers who have received probation once before are not entitled to another grant of probation. I mean, just given the lack of law saying that a defendant is given a right to allocute, and then given what a trial court is considering at a consequences hearing, it's the state's position that the trial court did not err in this case, whether this court gets there by conducting plenary review or plain error review. And if this court has no further questions, the state asks this court to affirm. Thank you.
Okay. Mr. Harwell?
I have, I think, 3 short points. One is, I think the state is, I understood, opposing counsel to now make the assertion that a defendant does not have the right to allocute at a probation revocation hearing. That assertion simply does not exist in the state's brief, and I think there's a consequence to that. The second point, and I may be somewhat repeating myself, on sort of the prejudice inquiry. Again, I point the court to its decision in Keithley, admittedly in the sentencing allocution context, but the logic, I think, is exactly the same. In there, the court said it is settled that a failure to comply with the mandates of allocution in the sentencing context ordinarily requires vacation of the sentence imposed without a concomitant inquiry into prejudice. This is so precisely because the impact of the omission on a discretionary decision is usually enormously difficult to ascertain. We hold if the trial court fails to afford a defendant the right of allocution, vacation of the ensuing sentence must follow automatically. That then provides the one limited exception if a defendant is already receiving the absolute minimum possible sentence. And the final point I will make, and I know I am repeating myself on this, but I think this is in essence the key as to the substantive issue, which is what this court has said in Rand and in other cases, is that as part of the second step of Dagnan, a court is to consider in determining the consequence the defendant's expressions of genuine remorse. And if a judge does not allow a defendant to speak, then the judge can't consider expressions of genuine remorse because the judge is preventing any such expressions from being made. So either Rand and other similar cases need to be overruled, and that provision needs to be removed from the case law. But at this point, that is a published binding decision of this court, and I think it is a necessary consequence of that decision that a defendant Certainly, if a defendant makes an affirmative request, as Mr. Beverly did through counsel here, that a defendant requests to speak to the judge at a probation revocation hearing, a defendant has a right to be heard.
Mr. Harwell, let me ask you, and I don't mean to be that student that asks the teacher a question at 2:59, a minute before the bell rings, but I'm curious. I think you would agree that a defendant is not required to make any statement, right? And if he chooses not to make any statement of remorse, then the court couldn't consider it. And there's a provision, there's at 40, I don't remember, it's the sentencing statute, 4035-210, I think is what it is. It says to determine the specific sentence and the appropriate combination of sentencing alternatives that shall be imposed on the defendant, the court shall consider the following. And then it lists a bunch of things. And number 7 is any statement by the defendant wishes to make on the defendant's own behalf about sentencing. And so that's the allocution statute. But the violation probation statute, 4035-311, says, according to what the defendant is allowed, the defendant must be present, as entitled to be represented by counsel, and has the right to introduce testimony in the defendant's behalf. It doesn't require or even provide for a statement from the defendant. So if the defendant wanted to express his remorse, why didn't he take the stand and present testimony on the witness's behalf?
Well, I would say, first of all, I agree that there is a difference in the statutes. And so, in a way, I guess I'm not making a specific argument grounded in the statute. But the structure of what happens at a probation revocation hearing has very much been developed by case law. The statute doesn't specifically set out the two Dagnan steps. It doesn't describe the different inquiries. It doesn't describe all of that, which then this court has continued to further elaborate on. And I'm sort of relying on, so whether that's sort of a case law argument rather than a statutory argument, I think that does make sense where so much of probation revocation is developed by case law. I think the idea that somehow Mr. Beverly should have taken the stand to talk about how sorry he is, amount of time, but I'll say two things. One, that's not really what testimony is about, right? That is talking about my character and my how I feel about things and making promises to the court. That's not something that is usually done by testimony. That is sort of typical allocution. And the second thing is, in the context of this case, that it sort of never would have made sense, right? At this first hearing, we were putting on the out-of-county witnesses to establish the facts of the violation, which Mr. Beverly wasn't disputing. And at the second hearing, defense counsel was saying, can we go deal with this out-of-county hold and put it off? And suddenly then the judge is saying, well, now I'm going to make a finding. And defense counsel says, well, can he at least say something? And the judge says no. So really there was never a time when it was really offered or appropriate, even if he had intended to do this by means of testimony. So we would ask that the court vacate the probation revocation ruling and remand for a new probation violation hearing. Thank you.
Thank you all. All right, that finishes the morning docket? Is that correct? Okay, so we'll adjourn till 1:30?
All rise. This Honorable Court of Criminal Appeals is adjourned until 1:30 this afternoon.
Sitting for 2 hours.